Hello, everyone. Welcome and thank you for joining us. My name is Jonathan Borrelli. I'm one of the employment lawyers at KMB Law. You can find us at kmblaw.com, and we are happy to discuss employment law with you today.
Hi, Jonathan, and hi, viewers. I'm Alex Boissonneau-Lehner. I'm also a lawyer here in the employment group, along with Jonathan, and we are excited to talk to you about some new developments that have occurred as of May 29th. You may
That's right.
remember from
what were you up to this weekend, Alex? Did anything change this weekend that you wanted to talk about?
Yeah, my weekend was ruined. The government very quietly released a new regulation on May 29th. That's a real game changer, I think, for employers who are facing difficulties managing their workforce. A lot of our clients had been worried about their temporary layoff period expiring, because unfortunately many of our employers, the reality is not every industry is suited for work at home, and there's been a reduction in work, and they're not able to keep their entire workforce on. So they were worried, and we were getting a number of calls about what's going to happen. Our 13 weeks are running up, and we said, we don't know, but stay tuned. And so now there's a new regulation. It's a real game changer. The bottom line is that it gives greater flexibility to employers in managing their workforce, and they don't have to worry as much about liability under the Employment Standards Act for cutting their employees' pay or hours. We'll get into the details about this over the course of this talk, but I think, Jonathan, what we need to do so that our viewers appreciate kind of the monumental change that was released on May 29th, they need to kind of understand what was the regime before this new regulation was introduced.
Right. So as the current rules around layoffs still apply in Ontario, but before the pandemic, if an employer was forced to lay off an employee, they could do so under the terms of the Employment Standards Act. And what that said was, if you want to lay off an employee, there's a short layoff and there's a long layoff. So a short layoff would be where the employee is not working and the layoff lasts for 13 weeks within a 20-week period. And if an employer wanted to lay off an employee for longer than that, they would have to satisfy some certain conditions. And the most important one, the most common one, being an employer continuing an employee's benefits for the entire length of the layoff. And if they did that, the employer would be able to lay off the employee for 35 weeks within a 52-week period. And so a lot of employers in the middle of March were forced, they had no other choice but to lay off their employees temporarily under the terms of the Employment Standards Act. Well, near the end of May, it was getting closer to the time when these 13 weeks would be met for many employees in Ontario. And so 2 weeks before the first wave of employees who were laid off on a short layoff occurred, the government came and went into the regulations under the Employment Standards Act and changed the law.
Yes, enter the government, the government to the rescue. So this should be a welcome relief to a lot of employers who are facing that problem. It's also kind of a sign that the law is moving very quickly. And Jonathan, as you'll recall, we actually did a webinar 2 weeks ago where we kind of were wondering about what was going to happen, about how the government or how the courts were going to address this. I was predicting that maybe it's something the courts will have to grapple with, but you made some predictions of your own. So if you don't mind, I want to just give a brief kind of play a 2-minute clip for our viewers, just to kind of set the stage for our discussion. And plus, Jonathan, it makes you look real good. It makes you look like a
we'll see about
law
that.
employment prophet. I don't look that great. I kind of look like a musketeer. I was experimenting with facial hair, but I learned my lesson since then. But one moment, I'll get this clip queued up.
And there are a lot of different ways that the law has to catch up to
Yes.
what is currently happening. And even for some of the employment laws that were recently updated and some other laws that were passed, some governments have retroactively changed the law. They set the date when certain changes can be made or certain things come into effect retroactively. But that's extremely rare. Normally, lawyers and society in general have months and months of time before a law is enacted. So for a law to be, or a rule or a new clause added into a law, for it to be added in and applied retroactively is extremely unique. How I would add on to that is, we're in kind of the middle part of May right now talking today.
True.
I suspect that the provincial government will update, in Ontario, will update the rules around layoff. Other provinces have done it. The federal government has done it for federally regulated employees. And it's different depending on what jurisdiction you're in. But for Ontario, they haven't touched it yet. Because right now, as of today, which is we're in the middle of May, the provincial government has not updated the law. But I suspect they will. Each government across the country has done it in a few different ways, but for Ontario employers, it's yet to be seen. Either the province will extend the amount of a short layoff, or they may make another change. It's really currently unknown, but I have a very good feeling there are changes coming along the way. There you have it, right from the horse's mouth.
That's right. So Jonathan, you were right about it on on basically everything. So the government did introduce new rules to address the problem. They made the regulations retroactive, and it's now caught up to the reality. What I like about that clip is, even though it's only from a couple of weeks ago, it shows how quickly the law is moving in this pandemic. So I think that kind of sets the stage for talking about the new regulation itself and how it's going to impact positively for many employers who find themselves in difficult circumstances managing their workforce. So the government has also recognized that that many employers across the province are in difficulty, that they can't keep their workforce on the same way that they have. Either there's not enough work or not enough money to pay them. So instead of me kind of summarizing what the government's real mentality was here in terms of introducing this new regulation, I'm going to read part of their news release, which they very quietly released, actually, I think on the Monday after the regulation was published. So the Ontario government is taking steps to help ensure that as the economy gradually and safely reopens, workers will have jobs to return to and will be protected from incurring unsustainable termination costs. The government announced that it has enacted a new regulatory amendment that will put non-unionized employees on infectious disease emergency leave during the COVID-19 outbreak anytime their hours of work are temporarily reduced by their employer due to COVID-19. This will ensure that businesses aren't forced to terminate their employees after their ESA temporary layoff periods have expired. Terminations triggered when temporary layoffs exceeded the permitted length under the Employment Standards Act can result in costly payouts, which for many businesses could be the difference between survival and closure. Under the new regulatory change to the Employment Standards Act, non-unionized employees who will have their hours reduced or eliminated because of the pandemic will be deemed to be on infectious disease emergency leave. Workers will remain employed with legal protections and be eligible for federal emergency income support programs. So while sometimes some people criticize the government for not really being in tune with what's going on, I think the crisis brings out the best in our leaders. And that news release is an excellent summary of essentially the effect of the law. And it shows that they were well aware of the problem. A little later in the game to release something, a solution than some of our counterparts, such as the British Columbian government. But hey, they were in time, and I think that will be a relief to many employers. So what's interesting, Jonathan, is that instead of extending the layoffs, which was one possible solution, and what they did in BC, they just extended the period for a temporary layoff. They came up with a pretty novel new solution.
Yeah,
and I think the key to this regulation is this new COVID-19 period, which begins retroactively, as you predicted, from March 1st, 2020, and ends 6 weeks after the state of emergency is declared to be at an end by the provincial government.
Right.
So, Jonathan, can you get into the details of what happens as a result of this new regulation? What happens if an employee's work is reduced or their pay is reduced during this COVID-19 period?
Right. So the new regulations say if an employer had laid off an employee during the COVID period, again, starting on March 1st, if an employer laid off that employee or those had to reduce the hours or wages of an employee, or perhaps reduce completely an employee's wages, that employee is not on a layoff and that employee has not been constructively dismissed. Instead, all of those employees are on a temporary, unpaid, job-protected leave of absence, like you mentioned, which is the infectious disease emergency leave. So I compare that similar to parental leave or a family medical leave under the Employment Standards Act, which means an employee has the time off. They're not required to perform any of their job duties. They're not to be paid. They're not on vacation, but they're on a leave of absence. And when their leave is over, they can come and take their job back. And so that the forced leave is something that I personally haven't seen in employment law across Canada. So what it is, it's where the government went in through the Employment Standards Act and amended all of the layoff letters that employers were writing back in March and April and perhaps May. And instead of telling the employee you are temporarily laid off work in accordance with the Employment Standards Act, those letters now say you are on a temporary unpaid job protected leave of absence. And it will last up until 6 weeks after the end of the state of the emergency in the province of Ontario. So, for the law to go and retroactively be changed, that does happen from time to time. But for the law to be changed and to rewrite these layoff letters, that's what I would call monumental, because there's no other changes that need to be made to records of employment. But if an employee was laid off, those rules around layoff do not apply to them. Those employees were not on a layoff. They were on a leave of absence the whole time. Whether they know it or not, that's what the law says. And so, there are some exceptions to that rule. And so if you have any questions about the specific exceptions or how your specific team or employees fall into that, give us a call, shoot us an email. We're at kmblaw.com, and we're happy to guide you with your specific needs and the specific requirements of your business. But generally speaking, if an employee was laid off, they were no longer laid off. They were on a temporary leave of absence.
Exactly. And it's, like I said, this should come as a great relief to a lot of employers who were not in a position to extend their temporary layoff. This transformation to this temporary prescribed temporary leave of absence makes things a lot easier. You don't have to worry about the weeks.
It does. because what was going to happen, like I mentioned before, there are short layoffs and long layoffs. Well, if a
Mhm.
short layoff where an employer does not continue the benefits for an employee, health benefits or RSP or pension or whatnot, if they're
Mhm.
not continued, then the employer would only have access to the short layoff. So after 13 weeks, those employees would have been terminated. Whether the employer knew it or not, or whether the employee knew it or not, technically their employment was terminated after 13 weeks without having any benefits or any other payments from the employer. And so, it's a huge game changer. And now, just like you said, with the press release that was announced, employers have a lot more flexibility to say, okay, they can breathe a sigh of relief, whether they're opening right now, like some industries are, whether they are will be opening soon, whether they'll be opening, let's say, in August. They have that breathing room because as of right now, when we're talking, the state of emergency in Ontario has been extended to June 30th.
Yes.
So if we take 6 weeks after June 30th, that puts us to approximately the middle of July. And I don't think it's outside the realm of possibilities that the government further extends the state of emergency, let's say another 2 weeks until the middle of July.
Yes.
And that would push the 6 weeks of the end of the COVID period until the beginning of September. And if I'm a betting man, if I want to make some predictions, I suspect, or I would predict that that will probably be in phase 2, or at least near the end of phase 2 by the beginning of September. So we can have schools and daycares reopen, taking all necessary precautions, and larger employers with offices downtown and offices everywhere can have their some employees, perhaps not all, but some employees coming back to work in the workplace, taking all reasonable precautions for PPE and physical distancing, and get the economy restarted. I have a feeling there are people walking through Queen's Park saying, from March to September, that would be, 5.5, 6 months. And there are probably people saying we can't have the economy sputtering for that long. We need to get things, open. We need to get people working. We need to get schools open. We need to have daycares open, so that we can, get back to getting the economy up and running again.
Jonathan, we'll have to see if your prophetic streak continues.
We
I
will
think
see.
I'll have to
We will see.
clip that part of the webinar one way or the other, and we'll see. We'll keep score at home.
Right.
But yeah, exactly. It provides employers far more flexibility. If they want to recall workers, they can. If they can't, then they don't have to worry, as long as it's the reduction of wages or the reduction in pay or elimination of either of those things has happened after March 1st, and they're recalled within 6 weeks after the end of the declaration of the emergency.
Right. But that wasn't all the changes, right? There were
No,
some
that's
other
true.
changes in the regulations.
There was. And one of those changes was an additional kind of shielding of employers against constructive dismissal claims. Because traditionally, a reduction of an employer's pay, or an employee's pay rather, or an employee's hours, could be seen as constructive dismissal. It's a fundamental change to their original employment arrangement. So an employee could say, I'm not accepting this reduction in pay or reduction in hours. I understand there's a pandemic, but I want to abide to my original agreement. Therefore, I'm not accepting this change. I'm considering myself constructively dismissed, which typically attracts the same type of liability as if the employer has actively dismissed, actively terminated the employee. Now, what this new regulation does is it specifically sets out that a reduction of pay or a reduction of hours during the COVID-19 period, which again, March 1st through to 6 weeks after the declaration of emergency is declared to be at an end, is not a constructive dismissal. So an employer cannot be liable for a constructive dismissal for the purposes of the Employment Standards Act regime, Ministry of Labor complaints. It's an open question, and it's something that the courts will still have to grapple with, is whether employee can successfully claim that they've been constructively dismissed. Because one thing employers should be aware of is that there's essentially two regimes operating. There's the Employment Standards Act, which prescribes kind of an employee's minimum entitlements, and then there's the courts and the decisions that have been rendered over years in both England and Canada in common law jurisdictions about employment. And what's not certain at this point is whether an employee will be able to claim constructive dismissal. That's something that we'll have to see. There's ways for the courts to grapple with it in favor of the employer, and there's ways for the courts to grapple with it in favor of the employee. But it's something that remains to be seen, and there'll probably be a bit of litigation around that area once the courts.
Yeah, and I've seen that there has been a lot of chatter online, lawyers and employment lawyers and employees alike commenting on these changes, saying, well, maybe it went too far or taking away too many rights from the employees. But we've talked to Alex, you too. We've talked to so many employers that were quite worried about not knowing what was going to happen after the 13th week of layoff. Because you have some employers who, perhaps there's an employer who doesn't provide any benefits of employment. They have an hourly worker, they pay their worker, and everyone's happy. That employer didn't have access to a longer layoff. After 13 weeks, the layoff would be deemed a termination. So these changes help employers to give them some some more wiggle room, of some pillow on ensuring that they can reopen properly. And so as part of these changes, perhaps let's say a business is permitted and ready to open as of July 1st. Well, that gives them, at least up until right now, it gives them 6 weeks for them to choose and manage their employees and ramp it up slowly. And as I said in the previous webinar that we had, it's up to an employer to manage their business. And if they don't require all of their employees all at once, this COVID pillow that was put into law allows the employer to say, okay, I only need a certain amount of employees. I don't need everyone back at work right away. And it also permits employers to say, okay, maybe they'll bring back some employees over 1 week and bring another group of employees over another week, so that they kind of share the reopening and training on the new requirements of their operation over a period of time, getting ready for not only when the emergency is declared over, but for when things are allowed to reopen completely. Of course, taking in mind all of the precautions that we have to take. And so, there was really, the government and employers were stuck between a rock and a hard place, because if all of these layoffs were deemed to be terminations, there would have been, mass terminations across the province, and termination pay flowing from that. And employers may not even, employers, I'm sure they would like to hire their employees if they could, but some of them may not have the cash flow to even pay the employees while they're working, because there is no work, or this extra termination pay. So it was really something that was necessary for the government to step in, so that these employees could have a job to return to in the future.
Yeah, and I think that's what's been missing from the discussion kind of amongst our employment lawyer peers, is this has benefits for the employee too. That flexibility that you mentioned is really important, because an employer is also obligated to keep its workforce safe. And if they terminated everyone 13 weeks ago, and they're facing the prospect of a deemed mass termination, they're going to feel compelled to recall everyone at once, even if it perhaps isn't safe to do so because of the work environment. So this gives the employer the flexibility, but it also protects the employees. It doesn't put them in a compromised position. It doesn't make an employer have to choose between mass terminations and reopening safely. So that's an element that's missed. And also, as you just kind of alluded to, it is beneficial for employees to give that employer that flexibility. Because what's the alternative? The alternative is potentially mass termination.
Mhm.
Would an employee who may be eligible for federal benefits at this time, emergency benefits at this time, would they prefer to have a job to come back to that's available and safe? Or would they prefer to be amongst, unfortunately, probably many people competing for fewer positions once the pandemic eases a little bit? So yes, some of our peers who represent primarily employees have said this is a real benefit for employers, but I think that the benefit to employees has been a little lost in the discussion.
Mhm. Yep. Like I said, it's a job protected leave. When the
Right.
leave is over, no later than 6 weeks after the end of the emergency, the employee is entitled to their job back, and that's what the law says. If the employee were to be laid off, the same protection isn't there.
Absolutely.
So, that's essentially the overview of those changes. Now, there are some other, still important, but not as important as the ones we discussed, changes to the regulations talking about how one defines a reduction in hours or a reduction in wages. What were some of the other changes?
There's a few exceptions in terms of terminations or resignations that occurred
Right.
during the period. But if that applies, that's something that you should probably check with a lawyer. Give us a call, and we'll take a look to see whether any of those exceptions apply, or if there's some questions as to whether you're not sure if your employee has experienced a reduction of hours or a reduction of pay because of the nature of your payroll. Give us a call. It's something we'll look at, and we'll make a determination whether the employee falls within one of those categories.
Right. So it's funny how much things can change over a few days. So if you're watching this and you have any other questions, feel free to reach out to us. We're at cambulaw.com. And thank you very much for watching, and stay tuned for our next webinar.
Thank you, and stay safe, everyone.
Thanks.